southwest suburbs of Chicago.
Chicago, we love Chicago, so you have our heart. So we're so excited everyone is joining us today. We are going to be talking about different options for divorce, kind of to stay out of the courtroom, which is going to be fantastic and a much simpler option, I would say.
Well, it can be not only simpler, but often more cost-effective and tailored specifically to your family.
Sounds great. I mean, that sounds what you need in that kind of situation. So give me one more second while I get this going here, everybody. So sorry.
We're here.
You know, it's always got to be like that. So Anna, what'd you do this weekend?
Well, I enjoyed the beautiful weather. So as long as we can do that while it's still summer or fall, we'll take advantage of that.
I know.
And of course, I was thinking about this presentation and all of you wonderful ladies and how we will help you make the right decisions for you and your family if you're contemplating a divorce. And of course, keep in mind that although I am licensed in Illinois, I try to be as general in some areas as possible so that you can apply it to your specific situation wherever you live. But I would absolutely recommend that you also consult with an attorney in your area to verify the information and to educate yourself, which is a big takeaway from today. Make sure you educate yourself about your options.
Definitely know the options, and we can always help you find somebody in your local area if you don't know anyone. We're more than happy to help you there. But now that we're all going, everybody knows that Purse Strings is here every Monday to do our Money Monday. And at Purse Strings, we believe that it doesn't matter if you have little money or a lot. Purse String programming helps women who are ready to put themselves first and get smart about money. So we're here to have real conversations, true life stories, really just bring out the real life, not just saving $5 on a cup of coffee, but, what do we really need to do to support our families, to have the best future for ourselves, and to, put ourselves first, which is also, really supportive to our families, which we always put first. So we're so excited to be here and have Anna with us, who's one of our Purse Strings approved professionals. And anytime throughout this, if anyone has any questions that they want to pop in the chat, they're more than welcome to. We know this is kind of a different topic, so if you want to keep your personal stuff to yourself, that's fine. But if you have any generic questions, we're more than happy to help you on this presentation.
And you are always welcome to contact me or Maggie offline after the program as well with questions. If there are questions that I can answer, I'm happy to, or we can help figure out who might be a good connection for you wherever you live.
Definitely. So it looks like we got some people jumping on here. We'll wait just one more minute and I'll give you a nice intro to Anna. Okay. Yeah, I know we got to enjoy the nice weather well before the Chicago cold comes.
Yes, unfortunately. It will be here before we know it.
Oh, God, it comes in a blink. So, yeah, awesome. Let's see here. All right. This is Anna. She focuses on what's important to her clients and helping them make educated decisions. When making decisions with a lifelong impact, it's important to discuss options. She believes in taking the time to go over all the options, even the nitty-gritty details. She also likes to bring in other professionals like financial advisors to discuss these decisions and what it might mean in the long run to support her clients' decisions. She just wants to make sure that they're all informed before making these life-changing decisions. She does many legal matters, including litigation, mediation, and collaborative divorce, which we're going to kind of talk about today. And she prides herself on providing compassionate divorce representation tailored to her clients' specific goals and an emphasis on frequent communication and results that her clients appreciate, which is awesome. And I just want to touch on that one thing in there and how you bring in other professionals, like financial professionals or advisors, to really see how it will happen, what will happen over the long run. We really talk about how when you make these decisions, you do need a financial team. It's not just one or the other, because you're great at mediation. You're not the financial professional, so we want to make sure everyone has a team. So it's always great to get a couple professionals on your side, have them talk and work together. They can talk to each other. which is so important.
Absolutely agree. And they can talk with you. And that's absolutely part of my presentation as well, because it's critical to you understanding what's happening and making informed decisions which impact your financial well-being long term. But
Definitely.
let's get started. So
Yeah,
we will.
I'll stop jumping the gun there.
That's okay. It's a great question and it's important. That's what we're here to talk about. So overall, we're going to talk about divorce today, and that is not an easy subject for anyone, and it's not an easy decision to make. If you find yourself in a space where you're considering the possibility of a divorce, it's very important to educate yourself so that your choices will benefit you and your family long term. What do we want to know? We want to talk first about types of divorces, roles of different professionals, and your top line considerations. So, as far as your options, pick the process that works best for you rather than having a process picked for you. Um, and your divorce process options are the traditional litigation, mediation, collaborative legal process, or collaborative divorce process, or do it yourself, pro se or self represented, or your kitchen table divorce. So, in terms of litigation, it is the most well known and most commonly used. The couple takes sides. Um, it's often contentious and antagonistic. Each side either has an attorney or maybe you're representing yourselves, but either way, the mindset is your respective gladiators will fight it out in front of the judge, and the judge will make a decision. It is public, and the judge determines the outcome based on the statutes and the case law. So there isn't really an opportunity to um, look at what's happening from the perspective of what's particularly important to you or your family if it's not something that a statute would allow. In terms of mediation, the couple would work with a neutral mediator to come to an agreement. The mediator produces a memorandum of understanding. It is different than a divorce judgment, and that is intentional because a mediator is required to be a neutral. And although they are supposed to be licensed in some other profession, in addition to being a trained mediator, so for example, licensed as an attorney, licensed by some governing body, or a mental health professional who also has their counseling or LCPC or Psych D degree that is also licensed by some governing body, can then become a mediator. But even though I, as an attorney, am also trained as a mediator, I cannot fulfill both the role of the mediator and the role of the attorney in the same case because there's a conflict. As the mediator, my job is to be a neutral, to help you and your spouse have the difficult conversation and give you a summary, a memorandum of understanding of what you're agreeing to. But I cannot then turn around and create the legal documents and represent one of you in the divorce case. And whenever there's an attorney involved, they're representing one of the people in a divorce case. If you hear of, we used one attorney for our divorce, well, that's actually a misnomer. One of the spouses was represented by an attorney, and that attorney explained everything related to the case to that person, their client. The other spouse is representing him or herself. So that concept of a conflict is important, and it's important to mediation as well. If you do choose to hire an attorney in your mediation process, most of the time that attorney would file the petition for divorce, would prepare the judgment, would prepare the marital settlement agreement, the financial agreement that's needed in the divorce, and if there are kids, the parenting agreement, and walk you through the process and conduct the final court appearance. Or you have to do it yourself. But the mediator remains a neutral and cannot advise or represent either side in a divorce. Um, and most often, when you hear of mediation, the couple would have conducted their mediation and then they bring in an attorney. But I often work with clients where I am hired as the attorney, but I advise my client through the mediation process. We explore different options so that when they go into their mediation session, they're informed, and whatever agreements they make, they do so knowing what their implications are for their long-term well-being, rather than committing to something, then seeing an attorney, and then realizing maybe they should not have committed to something. Our next option is collaborative divorce.
Can I jump in
And
and ask you a
yeah,
question
of
real quick?
course, of
What
course.
what is a memorandum?
Memorandum, it's just a written summary that basically says, in terms of the kids, we're agreeing to this as to child support. In terms of spousal support, we're agreeing to this. In terms of our cars, we're agreeing to this. And intentionally, that memorandum is structured in such a way that it cannot just be turned around and submitted to a judge. Most judges will reject it. And it's important to at least consult with an attorney for many reasons. But one of those is you want to make sure that as you're going through this process, you get it done right, and you get it done right the first time. Because in my experience as an attorney, and I've been practicing for 15 years, majority of that litigation, I have been trained as a mediator for 10 plus years, similar with collaborative process. And I can tell you, it is often more difficult and more expensive to try to fix something later, and it's not always possible, than it is to do it right from the get-go.
I'm sure, yeah, going back to court or anything like that does not sound great. So awesome. I'll let you keep going.
Oh, of course. And feel free to ask any questions. So, in terms of the collaborative divorce, it's a team approach. There are professionals involved who are trained as mediators and who are trained in the collaborative process. Each person is represented by an attorney, and that attorney participates throughout the process and is able to advise as you go, unlike in most mediation situations when the attorney is brought in at the end. Also, we can utilize the services of financial neutrals and a divorce coach or a child specialist or therapist. And you're probably thinking, all these professionals, how can this process be more cost effective for me? Well, in many ways, for those couples for whom it's suitable, it can be, because it focuses on your goals, concerns, and the outcome you're seeking to accomplish. It allows you for greater flexibility than the litigated process, although mediation does as well allow for greater flexibility. It is confidential, it is private. And when you have all these professionals involved, for example, the financial neutral could work with you to understand better what assets you're dealing with, what liabilities you're dealing with, and what the settlement actually means for you long term if you were to accept it. From the divorce coach perspective or a child specialist perspective, these folks can work with you to figure out a parenting schedule and a way of making parenting decisions. And in many instances, because they are trained for these specific roles, they do it better than asking your attorney to provide mental health or financial information. And in many instances, they allow the process to be more efficient, so you're saving money long term. In most instances, they also bill at a lower rate than an attorney would, so it would make sense to work with your mental health professional, with your coach, prepare for a meeting with your attorney, be efficient in your meeting with your attorney, and feel like you've accomplished quite a bit, and also save yourself money. So that's, one reason to work with professionals who are trained for specific roles. And then, of course, we have the kitchen table divorce, right? The do it yourself. Now, when you have folks representing themselves, the judge has to assume that you have all the knowledge that an attorney would, at least in Illinois. That's how our legal system is set up. So they cannot give you information. They cannot give you legal advice when you appear in court. They can refer you to resources like legal libraries or nonprofits that work with people who either have insufficient income to hire attorneys or maybe are looking for a less expensive option for divorce. However, we are in a difficult financial time for a lot of people. So be aware that many of these nonprofits are swamped with potential clients and they cannot accept all of the requests for representation. Also, keep in mind that if you are representing yourself, you will have to prepare all the legal documents and basically get the case through the legal system. Is it impossible? No. But the more complex the case, the more likely you are to make mistakes. So, again, consult with an attorney, educate yourself. Now, the impact of coronavirus on our court system and divorce process in general. One, court closures. So in Illinois, we're talking Cook, DuPage, Lake, Will, Kane, McHenry counties. There were initial court closures in March of last year because we frankly did not know what we were going to do, and there was obviously an ongoing health risk to the public. Eventually, the court system transitioned to virtual court appearances. And in some instances, some counties are allowing for some limited in-person court appearances. But for the most part, we are still utilizing virtual methods. So for example, if you have a litigated case, you are more likely to need multiple court appearances. And for each of those now, you are likely to be using virtual platform, for example, Zoom. There are counties where you might have in-person hearings or trials if those are truly contested matters. But for many of the court components, we are using virtual methods. And we also use them for mediation and collaborative process cases as well. We're keeping everyone safe while continuing the work, so that with those cases, we only need one court appearance at the end to present the judgment, the proposed judgment to the judge. And that is being done for the most part virtually as well. Because the coronavirus impacted the legal system, there are also significant case delays for the litigated cases because the system had to absorb not only the delay caused by no court appearances, but also by unanticipated number of emergencies that arose out of coronavirus impacting parenting time and other considerations. And historically, whenever there is an economic downturn, like now or in 2008 when we were going through a foreclosure crisis, generally difficult financial times impact the number of divorces we see filed. And because of that, also, there is greater delay in terms of the cases getting through the court system. So those of my clients who use collaborative process or mediation are able to conclude their divorces faster because we only need one court appearance to finalize the case. I offer that to you so you have additional information when making your choices as to what is appropriate for you and your family. Now, the roles of the professionals. As an attorney, I can only represent one person, one party, either husband or wife or whoever is one of the spouses. And my job is to advise clients regarding legal impact of your decisions, as well as to prepare the court documents. So that means the petition for divorce, the marital settlement agreement, the parenting allocation judgment, and any other additional documents to get the case finalized. If this is a litigated case, we also conduct discovery. And that means requesting financial documents, reviewing them, responding to the other side's requests for financial documentation, potentially conducting depositions, and preparing the case for trial so that if it goes to trial, we have all the evidence we need to present our side of the story to the judge so that he or she can rely on that documentation, on that evidence in making their decision. The attorney would also appear in court, would negotiate with the other attorney, and as I said, prepare the case for trial, conduct trial. If we are looking at the role of the mediator, then that person is a neutral and cannot give advice to either spouse. They are trained in mediation, cannot give legal, financial, mental health advice, cannot offer mental health counseling post mediation. They cannot order your spouse to do something. So it's not a coercive process. The only process where someone can order your spouse to do something is a litigated process. And that individual who can order someone to do something is a judge. Other than that, um, neither an attorney nor a mediator can order your spouse to do something. And as I mentioned previously, even if your mediator is trained as an attorney, they cannot give you legal advice or prepare legal documents while they are hired as your mediator. They can only perform one role. Now, in terms of financial professionals, they can be neutral or work with one of the spouses. It makes a difference what process you are hiring them for, because if you're using collaborative process or mediation, you can hire them as a neutral or to work with one of the spouses. But if you're looking at litigation, then that concept of neutrality goes out the window, and you are solely hiring this financial professional to assist you in preparing your case for trial or in evaluating the settlement proposal. Um, Certified divorce financial planners or analysts are folks who have additional training that helps them understand a little bit the dynamics of divorce and special considerations. Pre-divorce, they can help you understand the process, the information needed, and your assets and debts. During divorce, they can provide settlement options and ramifications. And after divorce, they can help you with planning and budgeting, but it's not necessarily available in all options, and sometimes not if they are the neutral. Again, it depends on how your process is structured. In terms of the divorce coach, they're the business manager for the divorce. They can help you focus on the goals and keep you process oriented. Your thinking partner, they can help you stay forward looking. As I mentioned, less expensive than an attorney, but they do not provide legal advice. Now, in terms of tips, pick the right process for you. By that, I mean, is your dynamic with your spouse best suited for collaborative process, mediation, or litigation? And sometimes you might want a certain process, but the case might not be suited for it. So, for example, you might say, I really want collaborative process, but your spouse does not agree. Well, then you won't be able to use collaborative process. Or you might contact me and say, yeah, I really think we have to go to litigation because we're dealing with this issue. And the more we talk, we realize that if you and your spouse are willing, and assuming we can bring in a financial neutral if it's a financial based issue, or a coach if it's an emotional or maybe an addiction issue, as long as we get right people involved in the team, you might actually be able to use collaborative process and it or mediation, and it could offer you a better long-term outcome than a litigated case. So it's very case by case basis, specific to your family and what you're going through at that particular point in time. Ask questions and educate yourself. It is absolutely critical that you understand not only what assets and liabilities you have, but details related to those assets. So, for example, let's say we're dealing with an offer that would give you some stocks. Well, take a look at what exactly is being offered. What are the tax consequences associated with that offer? What basis do these stocks carry? Because you want to make sure that you're comparing apples to apples and not apples to oranges. Set realistic expectations in light of your particular circumstances and the process which you are using. So, for example, you might find yourself in a situation that is difficult financially. And as much as you might wish that it was different, or that your divorce was happening 5 years ago or 3 years ago, when the financial circumstances were different. If the case goes to litigation, a judge isn't always going to be able to look back and say, yes, we're going to treat this issue as it was 5 years ago. Now, there are certain particular circumstances where they might be able to do that, but not always. So it's important to talk to your attorney and your team and figure out what your realistic expectations are and what do they mean for you long term. And again, know what is reasonable and stay goal oriented. The litigated process is really not set up to deal with addressing emotional concerns or anything other than the business of getting you divorced. And it might sound harsh, but when you look at it from the perspective of thousands, if not tens of thousands of divorce cases that judges and the system deal with, they simply do not have the bandwidth to offer um, individualistic, tailored approaches to each and every case. If you want to be able to have greater control over the outcome, that's when you might want to consider collaborative process or mediation to see whether they are well suited for your needs and for your family's needs. In terms of certain special considerations in divorce, we have parenting considerations, and for most folks, that means talking in terms of custody. Although in Illinois, we now talk in terms of parenting decisions and parenting considerations. In general, there are four major considerations for us: education, religion, medical, and extracurricular areas. And we have to figure out how will the parents make decisions in regarding those four areas. Will those decisions be made jointly, or one parent will take charge in any specific area? Sort of a menu approach. In terms of child support, in Illinois now, we look at both parents' income. 5 years ago, we were still looking at only that payor, the person who will be paying child support, and his or her income. Now we look at both parents' incomes, and we look at the number of overnights the child spends with each parent. And there are certain guidelines that are placed in our statute. But the parents can deviate from the guidelines. They just have to explain to the judge why they're deviating. And again, that's something that is often used and considered in collaborative process or mediated divorces. There are also considerations in terms of college or support for disabled children, and that support can continue post age 18 or high school graduation. But special considerations there might be that in terms of college or trade school, it's no longer a guideline. It's a little bit different. And with special needs children, you want to be careful not to impact any federal or state benefits. So consider how any support is structured and possibly consider a special needs trust. Now, think through financial aspects before you commit. What does that mean? Your budget and your cash flow. Do you have enough to live on? Will you? Liquidity of assets. And this is where the financial professionals can really be helpful. $100,000 in cash and $100,000 in retirement account are not the same. And it's important for you to understand that. How about any ongoing ownership? Whether that means real estate or business or anything else. Can you jointly own anything after divorce? Is it advisable? What would be the concerns or considerations? Taxes. Back to the example of $100,000 in retirement account, and what if you take a distribution or a withdrawal? How will that look versus taking the $100,000 in cash? Finally, any income or capital gains concerns. Again, very critical to understand that as you're assessing your settlement options. In terms of asset divisions, separate versus marital. What does that mean? Marital means jointly held or jointly owned, but just because something is in your name and was acquired during the marriage does not necessarily mean that it's a non-marital asset. Because in Illinois, everything acquired during the marriage is marital unless meets one of the exceptions in the statute. And those exceptions could be an inheritance or a gift or a property you owned prior to the marriage that was maintained in your name or maintained separate throughout the marriage. It can mean property that was specifically excluded in a prenuptial agreement or a postnuptial agreement. And so there are special considerations in terms of what is yours and what is ours in the divorce context. There is more to divorce and asset division than just a 401k. And if we are dealing with a 401k, does that mean that we will need a special order directing the plan to transfer funds to you, which is possible and happens quite frequently with divorces? What about real estate? Will you continue to co-own it for a certain limited period of time, or will it be sold? How will it be divided? Or is someone buying out the other person's share of equity in the real estate? And debts, including any student loans, any hidden assets. If that's a consideration, you absolutely want to talk to an attorney. Any business concerns, whether that's a business that was created during the marriage in which both of you were involved, or some other consideration. What will happen, not just in terms of valuing a business, but whether that business will continue to be operated, and if so, on what terms, by whom. Again, a lot to consider. And then there's the often asked question of spousal support. How is support determined? And it's also referred to as alimony or maintenance. Well, again, in Illinois, there are certain guidelines, and they look at income, length of marriage, earning potential, standard of living during the marriage, age, health, and some additional factors. And that guideline dictates how long support would last. And again, in a litigated process, more often than not, a judge would refer to the guideline. Can they deviate from it? Yes. Would they choose to? Again, depends on your case. Whereas with mediation or collaborative process, you can tailor the terms of your agreement to your family's needs. So you might have a bit more flexibility, assuming both sides are willing to have the conversation. How is support taxed? Well, any maintenance is no longer taxed to the recipient, but it is also not tax deductible to the person paying it. That's a big change. Prior to 2018, the payor, the person paying maintenance, was able to deduct from his or her income the maintenance payments, and the recipient paid maintenance, or I'm sorry, paid taxes on their maintenance. And the thought process was you had someone in a higher tax bracket taking a deduction, and you had the recipient paying taxes. And generally, the recipient would be in a lower tax bracket. So overall, the family unit saved on tax payments. So that's something to consider as well. Although that deductibility is no longer available, again, you might want to figure out and talk to your professionals what options there are in your specific circumstances. And then, of course, there are different classifications of maintenance, whether that means a lump sum buyout rather than receiving monthly payments, receiving a one large sum, or multiple larger sums, but for a shorter period of time than a guideline might direct. There is rehabilitative maintenance, which is intended to help someone re-enter the workforce and become self-supporting and self-sufficient. And then there's the indefinite maintenance, which often applies in situations where it was a long-term marriage, or there are certain considerations where someone will not be able to become self-sufficient. Again, important to talk to your professionals about your specific situation and circumstances. And finally, our financial considerations and the ever-present, unfortunately now, effects of the economic market disruption. So the recent market fluctuations can dramatically impact your assets, and the ability to separate the households can be impacted by your tightened budget. Mediation and collaborative process provide more flexibility in creative approaches and the accuracy of the settlement is more important when belts are tight. Settlements are generally binding, and future modifications generally apply to ongoing child support and child consideration. So it's important that you think through carefully as you're considering these settlement options before you commit. And that, ladies, is my presentation for today.
Wow, Anna, that was a lot of great information.
Thank you. Hopefully not overwhelming. I know there was a lot there.
I can definitely tell, you can tell just why there is so much of you need to go in person and have a conversation because everybody's situation is different, which is amazing. Are there any different laws, standards, I guess maybe just in Illinois, if you're married after so long, if things change in receiving money and or inserting pay and anything like that?
Are you trying to ask in terms of maintenance or spousal support? In general, the guideline that is in effect in Illinois right now says that the longer you're married, the longer you would be entitled to maintenance. So, for example, if you're married less than 5 years, you're looking at a year or less of maintenance. But if you're married for 20 years, then you're looking at length of payments equivalent to the length of the marriage or indefinite with two caveats. One, the judge has to first decide that maintenance is appropriate in your case, right? That's the first step. If they decide maintenance is appropriate, then we move on to the next consideration in terms of amounts and length of time. And with the indefinite, if you're looking at a 20-year marriage, unless the couple got married very early, at some point during that 20 years post-divorce, you might get into the area of someone wanting to retire. And you don't want to assume that a judge will require that person to work indefinitely to pay maintenance. So it's definitely something to consider and look at and potentially bargain for other concessions in your divorce process. So don't overlook the fact that whoever will be paying maintenance at some point might want to retire.
Wild.
Yeah.
We all want to retire someday.
Yes, we do.
It was a ton of great information. I can definitely see how going to a courtroom is it can be a crapshoot because they don't know your situation and why the things are the way they are, which makes sense in your family, but of course everybody's family is different. And really bringing these financial professionals to the table and understanding, if I keep the house, what does that mean? There are taxes on the house, there are payments on the house, there's upkeep on the house. Is that really worth it? And like you were saying, the $1 million in cash versus the $1 million in 401k are different. And, standing here, I couldn't tell you how they're different, but I know they are. Just the way the money exponentially grows. But some people, they think it's $1 million, I'll be set, I have $1 million, which it's not always like that, which I think is important to remember. And there are all these little things in there.
Nuances. You're absolutely right. And going back to the house, just because it comes up so often.
It's emotional.
It's emotional. And in many instances, women will say, I want to keep the house. Well, why do you want to keep the house? Because that's where we raise our family. That is where, the kids are attending school. I want them to continue and finish schools there. And if ultimately, after we look at it, my client says, I want the house, and I hear you, but I want the house, it's their decision to make.
Right.
But I will often ask them to consider and to definitely talk to a financial professional and consider what it means long term. Because if they're going to consume the rest of the settlement funds they're receiving to support this house on a short-term basis, and it will very much detrimentally impact their ability to retire at some point, that's a big consideration. And I have had clients, when presented with that information, say, you know what? Yeah, I don't want the house that much. Let's figure out an option B.
Definitely. It's hard. I mean, we all grew up in our houses, and I can see finishing school, but there's a lot of things I've been learning in this divorce process where you really have to plan of how this is going to affect you in the next 5, 10, 15 years, where at that point, you kind of want to get out of there, which is understandable, but you have to really plan out what are these long-term effects, especially if you've been home watching the kids and don't have job, or your pay is just not that high because you haven't been out of place for so long where they keep bumping you up. There's many different factors that fold in. So I think people, hiring a professional is so important when it comes to that.
Absolutely. Educate yourself, talk to a professional or professionals so that whatever choice you make, and it's your choice, but whatever choice you make, it's an informed choice.
Right.
Rather than having the process chosen for you. Like I said, so for example, if your spouse chooses to file a case in court and serves you with divorce papers, you might still be able to use mediation, but collaborative process most of the time is off the table.
Oh, so once they already went to court and filed, that decision is made. So you kind of have to have that decision before that decision.
So as difficult as it is to have someone say, I want a divorce, or if you're the one who's initiating, to say, I want a divorce, before you have that conversation or shortly after someone says that to you, educate yourself so that you can respond in a way that makes sense for you. Whether you choose to do nothing and wait for them to take those initial steps, or you choose to proactively say, as much as I would prefer another option, if you truly want to do this, let's look at mediation or collaborative process.
Right. That's a very good note to know. And we have people writing in how good the information and considerations were. So thank you.
Oh, my pleasure. I'm glad I was able to help you all.
So again, this is Anna Krolikowska.
Yes.
I
know it's a difficult last name.
And she's with Anna Krolikowska Law. You can always reach her at anna@annalaw.com. She's also one of our wonderful Purse Strings approved professionals. So you could reach out to her from our site, pursestrings.co. If you have any more questions, you can email me, you could email Anna. And if you're looking for a professional in your state, we can help you with that as well, since Anna serves Illinois, but we're more than happy to help.
And if you would like to check out my website for additional information, you're welcome to do so. And it's annaklaw.com.
annaklaw.com. Awesome. So thank you so much, Anna, for coming today and presenting. We'll be back in this group next Monday at 1:30 Central for another Money Monday. So we hope everyone has a great rest of the day. Bye.
Bye, everyone.